Hi everyone, welcome back to my channel. I recently released a video on the Michael Jackson estate versus HBO lawsuit where Michael Jackson's estate is suing HBO for $100 million over Leaving Neverland. That video was a very surface video, as I stated in the pinned comment that I put, so I didn't know whether there would be enough interest in the topic, so I didn't do a lot of digging because I didn't want to invest so much time and effort into a video that may not even end up being watched. Since releasing it though, it has garnered some interest, and I have had people reach out to me and linking documents and the contract itself and the appeal brief in order for me to analyze it and make a video on it. So this is what today's video is going to be about. We're going to be looking at the arguments put forward by both HBO and Michael Jackson's estate in relation to whether Leaving Neverland violated a non-disparagement clause and confidential provisions in a contract between the two parties, which was entered into back in 1992, pertaining to Michael Jackson's Dangerous Tour. So the agenda for today's video is as follows. First, we will look into the material facts of the case before moving on to the issues and an assessment of the arguments that have been put forward by both parties. Now, this case has already been determined in the sense that the Court of Appeal has already sided with the Michael Jackson estate and has ordered a private arbitration. I've explained in the last video on this topic what arbitration is, but essentially it's a form of alternative dispute resolution, so resolving disputes outside of court. And mind you, there's another important point I forgot to mention in the last video that was pointed out to me. The Michael Jackson estate won a public arbitration. They don't want it to be private. HBO are actually the ones who want it to be private. So one of the parties, being the Michael Jackson estate, from what I can see, is not trying to hide anything. They want the public to have access to these things. Now, the consequence of a private arbitration is privacy. So we as members of the public will not be able to have access to any of the documents or the evidence or the transcripts arising out of that arbitration. The only thing we may have access to is once the arbitrator renders their decision and then that decision is filed in court publicly, only then can we know what the decision is. So you might be asking, well, if we already know that the arbitration has been ordered, why are we talking about it in this case? Firstly, because as I said when I opened up the video, people asked me to dissect the arguments and to analyze them closely. But secondly, because a majority of these arguments that have been put forward by both parties will also be relied upon in the arbitration phase. So just because arbitration has been ordered, that doesn't mean that the Michael Jackson estate has won the lawsuit. They're suing HBO for $100 million, but it is the arbitrator who's going to decide whether that lawsuit can go forward. In July of 1992, Michael Jackson and HBO entered into an agreement. The subject matter was Michael Jackson's Dangerous Tour. So HBO wanted exclusive rights to air Michael's concert live in the States because he wasn't going to be touring in the States for that tour. Michael granted them exclusive right to air, of course subject to certain conditions. And these conditions are the main issue that has led to this lawsuit. As part of the agreement, HBO agreed to broad confidentiality provisions that were clearly stated in the contract to apply during or after HBO's relationship with Michael Jackson. So here, the wording is extremely important. In fact, interpretation of wording is probably one of the most important aspects when it comes to arguing contract law. As you can see here, the confidentiality provisions open up with this clause. HBO shall not, in any manner nor at any time, either during or after HBO's contact or HBO's relationship with licensor and or performer, use or disclose directly or indirectly, or even in the course of casual discussions, any of the following described information, which is the confidential information. Now, I have linked both the contract and the appeal brief in the description box for those of you who may want to read more detail in your own time. Now, the non-disparagement clause that we discussed in the last video is also housed within Exhibit 1 of the contract. It reads, HBO shall not make any disparaging remarks concerning performer or any of his representatives, agents, or business practices, or do any act that may harm or disparage or cause to lower in esteem the reputation or public image of performer or any person, firm, or corporation related to or doing business with performer. If you remember from my last video, I said that I couldn't really assess whether this clause still applied after the conclusion of the contract because I couldn't read the wording for myself, because part of my job as a lawyer is to interpret the words. Now that I can see it clear as day, it clearly does not have any time limitation stipulated whatsoever. Now, I'm going to be delving into the arguments made for and against, so just bear with me, because when I delve into their arguments, I'll also give you my personal opinions on this as well. But I will say that this clause and all the confidentiality provisions, in fact, clearly do not have a specific time period during which they apply, meaning there's no expiration date. And that's very important when it comes to interpreting contracts, because you can stipulate conditions that will survive the subject matter of the contract, being the tour in this case. So just because the tour ended in the law, that doesn't mean that all of the obligations and all of the conditions in the contract automatically end as well. If the contract stipulated that all of these obligations will end upon the termination of the contract, only then can the obligations end. If, however, very broad terminology is used, as is the case with this contract, then there is definitely room for arguing that these obligations still exist and must continue to be fulfilled. The contract also contains provisions that state that HBO cannot create or release any content in relation to Michael Jackson or any of his associates or corporations without first obtaining written permission to do so. And as the attorneys for the Michael Jackson estate argue, read as a whole, these confidentiality provisions effectively mandate that if HBO ever wanted to make a program about Michael Jackson in the future, and this includes programs using any information in any way related to Jackson from any source, HBO would likely need to work with him or his entities. This particular clause has also been a point of contention between the parties, and we will discuss why once we analyze the arguments. So then in 2019, as we all know, HBO released Leaving Neverland. And soon after that, the Michael Jackson estate sued HBO over the documentary for $100 million. And the reason is the alleged violation of the non-disparagement clause that we just looked at. So the main issues can be condensed into the following. First of all, did HBO's obligations end when the 1992 contract concluded in 1993? So in other words, was Leaving Neverland in direct contravention of the confidentiality clauses and the non-disparagement clause? And then secondly, does the arbitration clause still stand? Now, we know that it does because the Court of Appeal has ruled that it does indeed still stand. So as I said earlier, the focus of this video will be on the first issue. All right, so if you're new to my channel, I do want to say that I tend to summarize everything. It's just my style, and I also find that it's a lot easier to digest for the audience if I give you a summarized version. So HBO's main argument is that the contract ended after the subject matter of the contract ended, being the Dangerous Tour. So once both parties fulfilled their obligations pertaining to the Dangerous Tour, then the obligations couldn't be held to be enforceable after the conclusion of the contract. They also argue that the confidentiality clauses and the non-disparagement clause all relate to the tour, not to anything else. And of course, Leaving Neverland is, in theory, entirely separate to the 1992 Dangerous Tour. However, the Michael Jackson estate put forward very good arguments that link the two together. So they make it quite difficult, if not impossible, for HBO to argue that Leaving Neverland and the tour are entirely separate subject matters. They're actually quite related, especially when it comes to the allegations that have been made in Leaving Neverland. Now, as we discussed when we looked into the provisions, the Michael Jackson estate argue that the clauses and the wording of the contract is too broad to assign any specific time limit to them. And I agree. There is no wording whatsoever that even implies that these provisions cease to be enforceable once the tour ends or once the contract is concluded. In fact, it's quite the contrary. If anything has been made crystal clear in the wording of that contract, it's that the obligations pertaining to confidentiality will exist even after the conclusion of the relationship between HBO and Michael Jackson. That is clearly an indefinite period of time. In my opinion, I'm not an arbitrator. Usually arbitrators are retired judges and people really qualified in the area, so I am not an arbitrator and I have never been in such a position. But purely from a legal standpoint, the stronger argument here is definitely the one that has been put forth by the Michael Jackson estate. Now, HBO argued that the confidentiality provisions are limited to the subject matter of the contract, so the 1992 Dangerous Tour. However, the Michael Jackson estate pointed out, again in direct reference to the contract, that the confidentiality provisions are not limited to information obtained by HBO in connection with its airing of the concert. The described information or confidential information is defined in the contract to include any information of any kind or nature in any way related to performer, from any source or for any other reasons, including without limitation as acquired in the course of HBO's contact with licensor and performer. So in other words, the airing of the concert is but one of many examples of confidential information pertaining to Michael Jackson. Any source and in any way related to performer. Once again, it is indisputable that these words, this terminology, goes above and beyond the 1992 Dangerous Tour. There's no room for misinterpretation in this case. The lawyers that Michael Jackson retained back in 1992 did an excellent job of conveying the intention very clearly in this contract. Some contracts are written horribly. They're so ambiguous that they leave room for interpretation and argument. This contract, in my opinion, is not one of them. And in the same vein, by the way, and the Michael Jackson estate make this argument actually, HBO, a huge corporation, also had a team of legal experts, of attorneys that were really good at their job, presumably, and wouldn't have gotten into this agreement without being sure that it was in HBO's interest. Because at the time, Michael was the top performing artist in the world. There was no dispute. So this exclusive right that they got as a result of this contract was deemed to be worth all of these concessions and conditions that were going to be imposed on HBO. So HBO can't in good conscience make the argument of, we were duped, we were tricked into this contract, Michael Jackson had the upper hand. This wasn't just some small business owner or some individual who didn't have a monster legal team behind them to ensure that they got into contracts that benefited them. So we mentioned a provision that stated that if HBO wanted to use anything in relation to Michael Jackson, they must have first been given written approval from either Michael or, of course, he's not here with us anymore, his estate, his family, his corporations, etc. Anyone basically authorized to act on Michael's behalf. This never happened. As stated by the Michael Jackson estate, Michael Jackson's own family had no idea about Leaving Neverland until it was actually released, I believe, in Sundance Festival. This, of course, is another contravention of the contract because this clause also did not have a time limit. In fact, all of the clauses that are being relied upon by the Michael Jackson estate are broad in nature. So instead of repeating myself all the time, let's just put it out there. They have all been written in a way to ensure that these obligations will continue to be enforceable after the conclusion of the contract. Now, another argument that HBO has put forward, which I mentioned before, is that the subject matter of Leaving Neverland is not in any way related to the 1992 Dangerous Tour, except it is. The estate points out that the film contains allegations that have been made against Michael Jackson that were said to have occurred on the Dangerous tour. Therefore, the allegations in Leaving Neverland do indeed arise out of the subject matter of the 1992 contract. There's that link that I talked about. Therefore, HBO's argument that Leaving Neverland has nothing to do with the subject matter of the contract fails, at least in my opinion. Again, an arbitrator might find otherwise. Another argument that HBO will most likely put forth in arbitration, and that they have relied upon in the appeals process as well, is that two covenants in the agreement, so the payment and holdback clauses, were fulfilled. So they're saying that because these two clauses have been fulfilled, then both parties have been released from their obligations in 1993. This is again a repetition of the same argument of the contract ended in 1993, therefore everyone has been released of all of their obligations. But then Michael Jackson's estate shoots down this argument quite thoroughly. They provide an example of a situation where just because a couple of covenants were fulfilled, that does not automatically mean that any breaches in the future can't be legally pursued by the other party. And the great example that they gave is a clause in the contract that the concert can only be aired once. If HBO was to air the concert again, it would be a breach of that provision, and an action for damages would be subject to arbitration. So the fact that two other covenants in the agreement were fully performed would not preclude the claim. It makes no sense to say that the breach can't be legally pursued because it's in the future. The contract clearly took the future into consideration by stating that it can only be played once. Now, it would be a different story if it clearly stipulated a time frame. So this can only be played once during the tour. So as soon as the tour ends, HBO is free to re-air the concert as many times as it wants. That's not the case in this example. The example here is, again, broad terminology with no finite time period. This can only be played once, meaning even if it's 20 years down the line and it's played again, that is in contravention of the contract. And when a contract is breached, legal action can be taken. In this case, they want arbitration. The last thing I want to talk about in this case is the anti-SLAPP law issue. Now, anti-SLAPP laws are basically laws that protect freedom of expression and freedom of speech, basically the First Amendment. They exist to ensure that people or corporations don't start suing each other in order to stifle their freedom of expression. So if you want to say something or express yourself, you should be able to say it without fear of being sued. Of course, this exists within reason. You can't say anything you want. That's why defamation laws exist, but that's an entirely different can of worms. Defamation, as I put in my last video, doesn't really apply to the deceased. So a deceased person cannot be defamed. But this isn't a defamation case. They're focusing on the non-disparagement clause, and disparagement is not necessarily defamation. So HBO filed an anti-SLAPP motion arguing that compelling arbitration would violate their First Amendment right. So HBO is arguing that releasing Leaving Neverland falls under the First Amendment and should be protected. In my opinion, this argument was very far-reaching, and it did in fact fail. The Michael Jackson estate are not after an injunction, for example. Now, an injunction is an order made by a court that compels a party to do or stop doing something. It can be either temporary in nature, known as interlocutory injunctions, or final injunctions, which are permanent in nature. Asking for an injunction would be basically asking the court to order HBO to take down Leaving Neverland. That's not what the Michael Jackson estate is seeking here. They are merely seeking arbitration. They just want a forum where they can resolve their dispute outside of court. Now, of course, there are many arguments that can shoot down this anti-SLAPP motion. As I said, if you defame someone, then you can't claim freedom of expression if it turns out that the statements are false. Or, as in this case, if there is a non-disparagement clause that was broad and activated an arbitration clause, an anti-SLAPP motion can't be used to override those contractual provisions. California's anti-SLAPP statute does not apply in federal court to an attempt to enforce a federal statutory right. And here the right is under the Federal Arbitration Act to enforce arbitration agreements relating to interstate commerce. And relatedly, that a state statute could not stand as an obstacle to the enforcement of a federal statute. So the anti-SLAPP laws being relied upon by HBO arise out of a state legislation, not a federal one. So they're arguing that state law cannot be used as an obstacle to enforcing federal law. The district court agreed, and the anti-SLAPP motion was dismissed. And then when the case was appealed, which led to this decision of granting an arbitration, HBO pretty much relinquished any of its arguments pertaining to anti-SLAPP law. So they've dropped their anti-SLAPP law claims, at least at this appeal stage. They might bring them up again during arbitration. All right, that's it for this video. I know it's a lot of information, and I do hope that I've distilled it and simplified it in order to make it more easily digestible and understandable. I think that the Michael Jackson estate makes incredibly strong arguments. And of course, we can see that from the fact that the Court of Appeal agreed with them and ordered the parties to private arbitration. As I said, these arguments that we discussed in this video were discussed because they are the arguments that will be relied upon in arbitration. So what the Michael Jackson estate must demonstrate to the arbitrator is that the provisions were wide enough to cover the future and to cover the content contained within Leaving Neverland. So they've already succeeded on one account, being that the arbitration clause still stands despite the passage of time. That means that they have a very good chance of arguing that the other clauses, the other provisions, also still stand despite the passage of time because of the wide and broad nature of the terminology used, and more importantly, because of the express and clear lack of a finite period during which these obligations can be enforced. HBO's arguments are repetitive and they are quite weak. The gist of their argument is that the contract ended. They're not disputing that the contract existed, of course. They're not disputing that they were once bound by it. All in all, the contract was clearly written up very well on Michael Jackson's behalf, and it really anticipated these things in the future, very cleverly so. It will be very interesting to see how this case turns out. Now, I don't have a stake in this, of course, but I have already mentioned that I believe in Michael's innocence, and I do not agree with this constant harassment and disparagement of his name long after his passing. I do believe there are financial motivations driving the two men who are making these allegations against Michael, because as I said in my last video, they actually supported him during his criminal trial. As far as I'm concerned, and as far as most of us are concerned, he was acquitted by a jury on all counts, and it was a criminal trial. So this man has been through enough in life. I would think that people would at least let him rest in death. But money is just such an ugly motivator in a lot of cases, unfortunately. Ironically, Michael Jackson actually has a song about how people would do anything for money. As always, don't forget to let me know what you think in the comments below. What do you think of the prospects of this case? Do you think that the Michael Jackson estate will successfully argue its way through arbitration, or do you see obstacles that may enforce HBO's side? I also want to point out that I have finally set up a Patreon. It's been suggested to me multiple times, and honestly, I just wanted to grow my subscriber base before even venturing there. But especially as of recently, I have been investing so much time and effort and money into my content, and YouTube just refuses to monetize most of the content that I talk about because of the nature of the cases that I talk about. So if you are interested in supporting my channel and my content, the link is in the description box down below, and you'll find all of the information you need in there. If you liked the video, don't forget to hit that thumbs up button, and if you didn't like it, thumbs down. Also, if you haven't subscribed already, please don't hesitate to hit that button. Thank you so much for watching. Stay safe, and I'll catch you in a future video.